I'm Drew Stevenson, and this is a lecture about the case Chocolate Manufacturers Association v. Block. This is a Fourth Circuit Court of Appeals case from 1985 that addresses agency rulemaking and when is a supplemental notice required. Now, just by way of quick introduction for my students, this case is I teach it because it's a nice case for illustrating a point. Obviously, it's not a Supreme Court case, so it's not binding precedent everywhere, but it does highlight an important point to understand about notice and comment rulemaking. So informal rulemaking under Section 553 of the Administrative Procedure Act requires the agencies publish a proposed rule in the Federal Register, allow a period of public comment, and then maybe make some adjustments to the rule if they want and publish a final rule. And in that final rule publication, they have to respond to some of the comments. And so the question is, what happens when the agency makes a few too many changes to the final rule and it's too different from the original proposed rule that they published? That seems to undermine the notice part of notice and comment rulemaking. And that's what happened in this case. So let's take a look. And by the way, this is a case about chocolate milk from the standpoint of the facts. But our main takeaway here, if you want the quick and dirty take on the case, is the critical question is how much an agency's final rule is allowed to differ from the proposal that the agency originally published in the Federal Register. And if the agency alters its proposal a lot in response to the comments, then it may be important to give everyone else an opportunity to comment on that alternative proposal, and that's what happened here. So let's back up and we talk about what is our agency and what's the program here in question. There's a federal program called the Women and Infant Children, or WIC program. It's a federal program administered by the Department of Agriculture, and it provides nutritional assistance to pregnant and postpartum women and to infants and young children. And what happens is the Department of Agriculture sets regulations about which foods are covered by the program and provides cash grants to state and local agencies, which in turn distribute cash or vouchers for purchasing approved foods. So for those living in poverty, this really helps buy buy food for mothers with young children and pregnant women and women with babies. And as an aside, in my administrative law class, when we talk about the kind of poverty related cases, this is an in-kind type of assistance program from the government. In other words, we're not just giving them cash that they can go do whatever they want with or spend at Vegas. These are essentially coupons, so to speak, or a type of cash coupon that can be used only to buy food and only certain foods. So the original WIC statute and regulations focused on subsidizing foods that would provide certain nutrients known to be lacking in the diets of target populations. But weren't as focused on lowering the consumption of unhealthy foods. And so originally the idea was we were concerned that our poor communities or people living in poverty, that we actually had a problem in the early 20th century with malnutrition and hunger with the children. And so we wanted to encourage moms were basically to buy nutritious food. Well, by the time we get to the late 1970s, there's a lot of people concerned about children eating unhealthy foods, right? Sugary and fatty foods that I think breakfast cereals and things like that are marketed to kids, desserts, snack foods, and so forth. So the department's 1975 regulations specifically stated that flavored milk, including chocolate milk, is an acceptable substitute for regular milk for women and young children, but not for infants. In other words, they were drawing the line at giving babies chocolate milk. And in the 1970s, keep in mind, both Congress and the department became more concerned about the excessive sugar, fat, and salt content in a lot of the convenience foods sold in American grocery stores. And the WIC dollars, disbursements, were being used to buy a lot of these unhealthy, like sugar foods for the children. So Congress acted first here. They amended the statute in 1977 to make this concern explicit, that they wanted WIC money to be used to buy healthy foods. And so 2 years later, in 1979, the Department of Agriculture issued a notice of proposed rulemaking to address this issue. And so we're talking about the Carter era here. So the original proposed rule did not propose eliminating chocolate milk from the list of WIC-approved foods. And in fact, the proposed rule actually continued to include both flavored and unflavored milk in the food packages for women and children without special dietary needs. So throughout most of the 1900s, the mentality was, we're worried about malnutrition and kids going hungry, and it's if we can get them to drink milk because they want chocolate milk, that's better than not having anything, right? They get protein and other vitamin D and so forth from the chocolate and strawberry milk and so forth. And so they would have allowed WIC money to be used to buy chocolate milk, not just plain milk. But a lot of commenters, and mostly the people who are actually on the retail end of this social program, the local WIC administrators, were upset, and they wanted to eliminate chocolate milk from the program. They didn't think we should be encouraging kids, including kids in poverty, to drink that much sugar. And they pointed out that chocolate milk has more sugar and is actually more expensive than regular milk, and that including it in the WIC program is inconsistent with the nutritional and economic objectives of the program. In the final rule, the department bought in, right? They decided they agreed with this, and so they deleted chocolate milk from the list of approved foods. Well, the chocolate manufacturers are upset because they make a lot of money selling chocolate for putting in chocolate milk. And so they brought a lawsuit claiming the rule was invalid for noncompliance with Section 553 of the Administrative Procedure Act. And for my students, remember, that is our notice and comment rulemaking provision, or what we call informal rulemaking for regulatory agencies. Now, basically, they're saying the final rule took out chocolate, and they didn't have time to submit their own public comments to rebut the comments made that from the WIC people, basically. And so here's for those of you who like to highlight the zinger quotes, or the great lines in the opinion that really matter. Here's one for you I pulled out. Notice is adequate if the changes in the original plan, quote, are in character with the original scheme, and the final rule is a logical outgrowth of the notice and comments already given. Other circuits have adopted some form of the logical outgrowth test. And that's part of the takeaway that you really should get about this, from this case, about the larger body of administrative law, that for notice and comment rulemaking, the final rule needs to be what we call a logical outgrowth of the proposed rule, even if there are some changes. Or here we go, stated differently, if the final rule materially alters the issues involved in the rulemaking, or if the final rule substantially departs from the terms or substance of the proposed rule, then the notice is inadequate. Concluding here, and at the end of the opinion, the court concludes, quote, affected parties did not receive a fair opportunity to contribute to the administrative rulemaking process. And that process was ill-served by the misleading or inadequate notice concerning the permissibility of chocolate-flavored milk in the WIC program, and does not serve the policy underlying the notice requirement. In other words, we kind of forgot the notice part of notice and comment rulemaking. Now, before I go to our review question, I just want to make sure that you understand. Notice and comment rulemaking requires an agency to publish a proposed rule, allow a period of public comment, and 90 days is very typical. The APA actually doesn't specify a period, and sometimes for controversial rules, the agency will allow a longer period. But think about if we didn't have to have some connection between the final rule and the proposed rule, it basically undermines the whole point of doing notice and comment rulemaking, right? The agency can ambush the regulated industry with a completely different final rule out of the blue. Or they could even kind of play a game of publishing a proposed rule intentionally downplaying what their true intentions, what they're planning to do with the final rule. And so the courts don't want that. So we've kind of created this logical outgrowth rule to make sure that the final rule under APA rulemaking is connected to the original published rule. So let's go and just do our quick review question to make sure that you are paying attention. During the notice and comment rulemaking, is it permissible for an agency to change its mind after reviewing the comments and publish a final rule that is substantially different from the original proposed rule? Yes or no? Hopefully you know the answer to this, or you haven't really been paying attention and need to rewatch this video. And that concludes our lecture about this case.